What if I told you that American courts have fined, arrested, and imprisoned Amish men and women for practices they considered as sacred as prayer, and that in most of those cases, the law won and the Amish had no choice? The law they never asked for. The Amish did not come to America looking for a fight with its legal system. They came looking for land, separation, and the freedom to govern their own lives by their own rules. For most of their history in this country, that arrangement worked. They stayed in their settlements, the outside world largely left them alone, and the legal system rarely had occasion to notice them. Then, across the second half of the 20th century, everything changed. Compulsory education laws expanded, child labor regulations tightened, safety codes reached into areas that had always been left to individual judgment. One by one, American courts began telling the Amish that their faith did not exempt them from the law of the land. 1. The education arrests. The first major collision between the Amish and American law came over school. Amish communities have always ended formal education after 8th grade, believing that further schooling introduces worldly values that undermine the faith and that practical apprenticeship teaches everything a young person actually needs. For generations, this was simply how things worked. Then, in the late 1940s and through the 1950s and 1960s, states began raising the compulsory education age to 16. And suddenly, Amish parents who pulled their children from school at 14 were breaking the law. The arrests that followed shocked outside observers. In Lancaster County, Pennsylvania, over the course of just 5 years in the 1950s, more than 125 Amish parents in a single township alone were jailed for refusing to comply. The confrontation ultimately reached the United States Supreme Court in the 1972 case Wisconsin versus Yoder, which ruled in the Amish community's favor and remains one of the most significant religious freedom decisions in American legal history. But for the decades before that ruling, Amish parents went to jail for a practice they considered as natural and theologically grounded as baptism itself. 2. Child labor in the sawmills. When Amish children finish 8th grade, they do not go to high school. They go to work. This is not considered exploitation within the community. It is considered education of a different kind, apprenticeship alongside parents and skilled community members that teaches the practical competencies of Amish adult life. A 14-year-old working in his father's sawmill, furniture shop, or on the farm is, in the community's understanding, continuing his education in the only form that actually matters for the life he is going to lead. The United States Department of Labor sees it differently. Federal child labor laws prohibit workers under 18 from operating hazardous equipment, which includes the power saws, planers, and heavy machinery common in Amish woodworking operations. In the 1990s and 2000s, the DOL conducted enforcement sweeps through Amish communities in Pennsylvania, Ohio, and Indiana, levying thousands of dollars in fines against Amish sawmill operators for employing underage workers. Congress eventually created limited exemptions for Amish vocational training, but the enforcement pressure never disappeared entirely, and the tension between federal child labor law and Amish apprenticeship practice continues in various forms to this day. 3. The safety triangle standoff. Every Amish buggy shares the road with vehicles traveling at 60 or 70 miles per hour. States have responded to this with a simple requirement: slow-moving vehicle triangles, the bright orange reflective markers that warn drivers of a vehicle ahead traveling at horse speed rather than highway speed. Most Amish communities comply, but the most conservative Schwarzentrooper Amish, whose Ordnung prohibits the use of bright colors and worldly symbols on any of their possessions, have refused on religious grounds for decades, arguing that the triangle violates their faith as directly as any other forbidden technology. The legal confrontations that followed played out across multiple states. Schwarzentrooper Amish men were arrested, fined, and jailed repeatedly for refusing to display the triangles. Courts consistently ruled against them, finding that public safety requirements outweighed religious exemption claims in this context. Some communities eventually negotiated compromises using reflective tape in gray rather than orange, or lantern arrangements that met minimal visibility standards without the triangle itself. Others continued to refuse and continued to receive citations. The standoff between the most conservative Amish communities and state traffic safety laws remains unresolved in some districts even today. 4. Septic tanks and building codes. Modern building codes and sanitation regulations were not written with the Amish in mind, and they create a steady stream of legal friction that most outsiders never hear about. Septic system requirements, in particular, have generated repeated confrontations. Amish communities have traditionally managed waste through outhouse systems and composting practices that predate modern sanitation infrastructure. When counties began requiring modern septic systems for all occupied dwellings, Amish families who had lived on their land for generations found themselves in violation of regulations that required expensive installations, their theology considered unnecessary. Building codes have created similar conflicts. Requirements for smoke detectors powered by electricity, specific wiring standards, and structural specifications designed around modern construction methods all create friction for communities that build their homes and barns without any of these systems. Local health departments and building inspectors have taken Amish homeowners to court repeatedly over these violations, sometimes resulting in fines, court-ordered modifications, and in some cases, threats to condemn structures the community had occupied for generations. The most conservative communities have simply paid the fines and continued their practices. Others have negotiated accommodation arrangements that allow battery-powered alternatives or other compromises, satisfying the code's intent without requiring the specific technology the original regulation assumed. 5. The raw food raids. Amos Miller is an Amish farmer in Lancaster County, Pennsylvania, who has been in a running legal confrontation with federal food safety regulators for years over what he is allowed to sell his own customers. Miller operates what he calls a private food club, selling raw milk, raw cheese, and unprocessed meat products directly to members who specifically seek them out and sign agreements acknowledging the products are not commercially regulated. The federal government's position is that the products Miller produces and distributes violate USDA food safety regulations and operate outside the legal framework for food commerce regardless of any private agreement between seller and buyer. The raids on Miller's farm drew national attention and a specific kind of public sympathy because the image of federal agents confiscating Amish-produced food from a plain farming family struck many observers as an overreach. Tucker Carlson covered the story. Libertarian commentators cited it as a case study in regulatory excess. Meanwhile, public health officials pointed to a listeria outbreak linked to Miller's products as evidence that the safety concerns were not theoretical. The courts sided repeatedly with the federal government, levying fines that at one point reportedly exceeded $2 million and placing Miller under court orders restricting his operations. Miller has largely continued his practices regardless, treating the confrontation as a matter of religious conviction about food sovereignty that no federal agency has the authority to govern. 6. The beard-cutting conviction. We covered the Sam Mullet case in a previous video, but it belongs on this list because it represents the most dramatic criminal conviction of an Amish person in American legal history. In 2012, Sam Mullet, the self-appointed bishop of a breakaway Amish compound in Bergholz, Ohio, was convicted on federal hate crime charges for ordering the forcible cutting of the beards and hair of other Amish men and women whose religious practice he had decided to punish. He was sentenced to 15 years in federal prison. The conviction shocked both the broader Amish community and legal scholars for different reasons. The broader community was horrified that internal Amish conflict had escalated to the point of federal prosecution, and that the story of what happened inside the Bergholz compound was now public record. Legal scholars found the case fascinating because it applied the Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act to an Amish-on-Amish offense. The defense argued this was internal church discipline protected by religious freedom. The jury and the federal court system disagreed, and Mullet's conviction established that American criminal law reaches inside Amish community boundaries when the conduct inside those boundaries rises to the level of a federal crime. 7. The gun charges. In 2022, federal agents from the Bureau of Alcohol, Tobacco, Firearms, and Explosives raided the Lancaster County property of Reuben King, an Amish man who had been operating what authorities described as an unlicensed firearms dealership from his dairy farm. They found over 1,000 guns. King had been selling firearms to Amish and Mennonite buyers for years, operating outside the federal licensing system that governs commercial gun dealers. His defense was rooted in a specific practical problem. Amish men who want to legally purchase a firearm from a licensed dealer are required to present a government-issued photo ID. The Ordnung forbids photographs of people. A devout Amish man therefore cannot comply with the federal identification requirement without violating his faith. King had, according to prosecutors, solved this problem for his community by sourcing and reselling firearms without going through the licensed dealer process at all, bypassing the photo ID requirement entirely. He was convicted on federal weapons charges and sentenced to prison. The case illuminated a genuine tension between federal firearms law and Amish religious practice that the law had never specifically addressed, and it raised a question that remains unresolved. How is a devout Amish man who has no photo ID supposed to legally purchase a firearm in a country where photo identification is required for every licensed gun transaction? 8. Medical neglect rulings. The Amish approach to healthcare relies heavily on home remedies, herbal treatments, community midwives, and prayer, with modern medical intervention sought in emergencies but approached with significant caution in less acute situations. For most adults making decisions about their own bodies, this is legally protected. For children, the legal picture is considerably more complicated, and American courts have repeatedly ruled that parental religious belief does not override a child's right to medical care when that child's life is at risk. Cases involving Amish children who died from treatable conditions after parents declined conventional medical treatment have resulted in criminal charges in multiple states. Faith-healing defenses, arguing that medical decisions were protected religious practice, have been rejected by courts that consistently found that the state's interest in protecting the life of a child outweighs a parent's religious freedom when the two come into direct conflict. These cases are among the most painful in the legal history of the Amish and outside world's relationship because they involve genuine grief on all sides. Courts have consistently ruled that a sincere theological framework cannot be a legal defense when a child dies from a condition that medicine could have treated. 9. Social Security resistance. The Amish have always operated their own mutual aid system for members who face hardship, illness, or old age. They consider participation in the government's Social Security program both unnecessary because the community takes care of its own, and theologically problematic because it represents a dependence on the state rather than on God and community. For decades after Social Security was established in the 1930s, Amish employers simply refused to withhold the tax from their workers' wages or pay the employer's share themselves. The Internal Revenue Service responded with enforcement. In some cases, agents seized Amish property, including horses and farming equipment, to satisfy unpaid Social Security tax obligations. The confrontations were deeply upsetting to communities that had generally managed to stay out of the legal system's reach, and they generated congressional sympathy that eventually produced a resolution. In 1965, Congress passed a specific exemption allowing self-employed Amish individuals to opt out of Social Security on religious grounds. And in 1988, the exemption was expanded to cover Amish employees working for Amish employers. It is one of the few cases in which the Amish successfully lobbied the American legal system to change the law rather than simply absorbing the consequences of resisting it. Conclusion: 10 confrontations between the Amish community and the American legal system. Education arrests that sent parents to jail for keeping their children home. Child labor fines that threatened the apprenticeship system the community's economy depended on. Safety triangle standoffs that put conservative Amish men in county jails for refusing to put a bright orange symbol on their buggies. Building code violations, food safety raids, beard cutting convictions, federal gun charges, medical neglect rulings, and a decades-long battle over a retirement tax the community never wanted to pay into. Taken together, they paint a picture of two systems, one built around individual religious freedom and one built around the uniform application of law to everyone within its borders, repeatedly colliding in ways that neither side fully anticipated.